Second act we have is Employment Standards Act. We will learn the Employment Standard Act and the terms under this act. Employment Standards Act of Ontario sets minimum standards that the employers must follow for most of the workers in the province. Security guards are no exception and would be covered by these standards. Hours of work. The ESA sets the maximum hours of work for the security guards to 48 hours in a work week. After 8 hours worked, the security guard must have a minimum of 30 minutes of rest. For example, if a security guard is scheduled to work from 9 a.m. to 5 p.m., he must have a 30 minutes break time. Overtime pay. Security guard must be paid overtime pay equal to 1.5 times their regular rate for any hours worked beyond the 48th hour in a work week. For example, if a security guard normally earns $20 per hour and works 50 hours in a work week, they would be entitled to 44 hours at their regular pay rate and 6 hours of overtime pay at a rate of $30 per hour. Then minimum wage. The minimum wage for a security guard in Ontario is $17.60, and some employees may be subject to the exemptions that allow them to be paid a lower minimum wage. Then the Employment Standards Act requires employers to provide 2-week vacation for the security guards after completing 12 months of service. The vacation pays are set at 4% of gross earnings within 5 years and 6% after 5 years. For example, if a security guard earns $40,000 per year, they would be entitled to $1,600 of vacation pay at the rate of 4%. Public holidays. Security guards, like most workers in Ontario, are entitled to enjoy public holidays off. If they work on public holiday, they are entitled to be paid at 1.5 times their regular pay rate. There are 9 public statutory holidays in Ontario that are New Year's Day, Family Day, Good Friday, Victoria Day, Canada Day, Labor Day, Thanksgiving, Christmas, and Boxing Day. Sick leave. The employee is entitled to take a job protection of up to 3 days off each year without pay. The employee is required to inform their employer in advance or as soon as possible by any means of notice. It can be oral, written, voicemail, etc. Pregnancy leave, parental leave. An employee who is pregnant or is entitled to take a leave of absence without pay for up to 17 weeks unless her due date is less than 13 weeks after she started working for the employer. Parental leave. After the birth or adoption of a child, a parent is entitled to take leave of absence without pay for some time to take care of the child. The length of parental leave depends on whether or not employee also took pregnancy leave. Then termination notice and pay. Continuously employed for at least 3 months, the employee with either written notice of termination, termination pay, or combination of both. Certain employees are not entitled to notice of termination or the termination pay under Employment Standards Act. For example, someone is guilty of willful misconduct, disobedience, or willful neglect of duty, an employee who worked less than 3 months. For example, security guard who are caught sleeping on the duty is a misconduct, so he is not entitled for such things. Labor Relation Act. We will discuss Labor Relation Act with scenarios. Labor Relation Act sets out the rules and regulations for the things like collective bargaining, strikes, and lockouts, and unfair labor practices. Unfair labor practices might include the things like refusing to negotiate with a union, firing an employee for trying to form a union or participate in the union activities, or discriminating against an employee based on their union membership. For example, let's say that a security guard named Tom is a part of union that represents security guards in his company. And if the company refuses to negotiate with the union, Tom and his fellow security guards might go on strike to try to pressure the company to come to the bargaining table, and the Labor Relations Act would provide guidelines on for how the strike would proceed while protecting the rights of both the company and the employees. Alternatively, let's say that another security guard named Mary is punished or fired for attempting to join a union. This would be considered as unfair labor practice, and the LRA would provide Mary the protections and a process for filing a complaint.